Well, folks, I hope that you listened to our first podcast, the background podcast, that was all about how we have an intersection where private and public property meet. Okay? How does this right or that right? Is one priority over the other? Are they the same? Or do they, when they merge, does one start and one end? Is there a blending? What's the story? Well, the first video / podcast we did was background in all of this. Now I have two attorneys, Tom Stonecipher and Nick Vandenbos, who are attorneys I've worked with for a long time. They have went into a super deep dive of this stuff. I mean, like a super deep dive. They have been researching this for me for about 6 months. And from this, they've also enlisted the help of 3 legal scholars, law professors, who have made a big part of their career and their study about public land law. So, with the background we gave you in the first podcast, I think now we're going to get into something where your mind is going to be stretched on this topic in ways that maybe it hasn't thought about it before. I know for me personally, I'd always been told by attorneys that, oh, this is just cut and dried. This is black and white. This is what it is. No, it's not quite that way. So I'm not going to be the legal expert. And I would suggest none of us, unless you are a legal expert, should be making decisions without getting legal expertise. So this is a quick video intro to what's a long podcast, over 2 hours, talking about this topic. I hope you'll leave your comments down below, because one of the things we're going to do is take all the feedback from these first 2. We're going to wrap that together, and I'm sure we're going to have a third podcast on this topic. So here we go. Tom and Nick are going to talk about the legal aspects of intersecting property, private and public. Hope you enjoy it.
Hey folks, Randy Newberg here. Welcome to Loopholes Hunt Talk Radio.
As I went walking, I saw a sign there, and on the sign it said no trespassing, but on the other side it didn't say nothing. Well, that side was made for you and me.
Hey folks, Randy Newberg here with another episode of Loopholes Hunt Talk Radio. This is episode number 179. And more importantly, this is part 2 of the corner crossing series that we're doing, that I know for sure is eventually going to have 3 episodes, and depending on the feedback and everything else, we might end up with 4 episodes. Today, we get into the real details of this. With me are attorneys Tom Stonecipher and Nick Vandenbos. Tom, Nick, and their firm have done a lot of property law work for me and my CPA clients. And they're also very well versed in this, because quite a few months ago, I hired them to help me start looking into this issue. And the issue I'm talking about is when public and private property rights intersect, as they do with corner crossing or adjacent boundaries between neighbors where it's public and private. So I've been working with them for quite a while on this, and the project that I told them I had in mind was a series of podcasts, but also to help me better understand the evolving status of law and how law is not static, it's moving and changing. And so we're going to get into the details of that in this podcast. Now, in the prior episode, number 178 that we published last week, you're going to find in that podcast an entire background of what brought us to this discussion, how we got here, what is corner crossing, how this even happened, that the land ownership pattern ended up in this way. the details of this Wyoming case that you're going to hear us refer quite often to a Wyoming case that has popped up. I didn't know that case was going to come when I started this project, but it's out there, and it's a really good example of the topics and the issues and the, if you want to call it, nuances of law that you're going to hear Tom and Nick talk about. So you're going to hear us talk about a lot of things that were covered in the previous podcast. So I'd strongly suggest that you go and listen to episode 178, which is called Corner Crossing Part 1. It's a shorter podcast than this one, because this one, I suspect, looking at the outline and script, is going to be pretty long. But I think that prior podcast will give you a lot of benefit to prepare you for a lot of the topics, the ideas, and the context in which I've approached this and the context in which I've asked Tom and Nick to approach this. So with that, I'm going to do a few sponsor notes, and we will get into the details of the intersection of private and public property rights, kind of like what we see when the topic of corner crossing comes up. So really appreciate you being here. Big thanks to Leupold Optics, Leupold's title sponsor of this podcast, and a big advocate for all the things we love: hunting, shooting, conservation, access, you name it. Go to leupold.com, check them out. Hopefully you'll buy some Leupold Optics in your next purchase. Another great company, another family-owned company, Nosler Ammunition. Again, big supporters of all the things that we love, right? Shooting, hunting, you name it. Go to nosler.com, check out all their stuff. A lot of stuff now you can buy online at their website. And when you're buying ammo or components, I hope that you'll think of Nosler. We have Mystery Ranch backpacks. Been using them since, well, long before I started this platform. If you want to save 10% on your Mystery Ranch backpack, go out to the Go Hunt Gear Shop. Go to gohunt.com, click on shop, look at Mystery Ranch, put one in your cart, and when you do that and you check out with promo code Randy, they're going to give you 10% off that pack and off anything that isn't on sale. So all regular priced items, you get 10% off with promo code Randy. I think there are a couple products or a few companies that require you to stick to map pricing. So there might be a few things that it doesn't apply for, but it's a good way to save a lot of money. My buddy Corey Jacobson will give you $20 off his elk hunting University of Elk Hunting course. Go out to elk101.com. And when you sign up, use promo code Randy and get $20 off that. It is application season, so go to Go Hunt, sign up for the Insider, and you'll get all the things that we use for our tag applications, our research, our e-scouting, our mapping. The list goes on and on. And when you do that, use promo code Randy, and they're going to give you $50 of credit in their gear shop when you use promo code Randy. And last, I hope you'll look into our new subscription platform. It's called Fresh Tracks Plus, and you can find it out at freshtracks.tv. So, thanks for being here. I'm about ready to hit the button. And when I do that, Tom and Nick are here, and we are going to have probably a couple hours of talk where they explain, not me, I'm not the attorney, they are. They're going to explain so much about the intersection of private and public property rights. So thanks for being here. Here we go. Well, folks, I told you that today was a podcast I've been looking forward to for a long time. I am at a law firm in Bozeman. I have two attorneys here with me who I've known for a long time. They know my crazy ways. They know that I get my nose pinched in the door every once in a while. And they've been helping me on this whole idea related to property law, related to corner crossing, related to all kinds of stuff. We'll get into it all, but I am going to let them do a disclaimer, but first I'm going to introduce Tom Stonecipher and Nick Vandenbos. Did I say that right, Nick?
You Vandenbos. Yeah, I think you had it.
All right. So anyhow, they are. Can I put a pitch in for your law firm? No. Okay.
You say, I don't think so.
All right.
The fact you're using
Tom's
this is good.
modesty is coming out here. Who we don't have here is one of their now retired partners who has been my hunting buddy. And I don't know, I've known your retired partner, Buzz, since 1991.
Wow.
He would hire me in as an expert witness in cases. And then I got a lot of free legal advice, and he'd always tell me, now this advice is worth what you just paid for it.
Yeah.
Related to this stuff. So
You're not the only person who thinks about that with Buzz.
and he's not even here to
And
defend
he's not even
himself. But anyhow, folks, we got to do a disclaimer because this is me trying to lead a discussion with two very smart attorneys who this is their world. So you guys need to give a disclaimer to make sure that no one takes this as legal advice and then you end up having your malpractice carrier.
Sure, we do. I mean, we can only afford a tiny amount of insurance, Randy. And so we ought to do that. This is Tom Stonecipher. And with Nick Vandenbos, and Nick and I have worked together for a number of years. I guess the disclaimer is this. Nick and I have studied a lot of the law dealing with public land, public trust doctrine, things of that sort. And we have focused our attentions on that and what public land means and access in order to be able to have a conversation with you. And so we'll talk about statutes and cases and things of that sort and how law works today. But this is not in any way legal advice. We're not giving any legal opinions here, one way or another. We're just kind of talking about where the law might be, what concepts are, and how it might work in any factual setting. And so no one who's listening should say, holy cow, Nick said, so I'm going to go out and do X, or Tom said, and I'm going to go out and do Y.
Yeah.
We're here to talk with you about the concepts that are important that we discuss in this podcast.
Yeah.
That's exactly right. I second that 100%. And I'd hate for someone to hear us talking and then get a wild hair and go out and do something based on our conversation, because that's not what we're doing here. We're just talking about what the law appears to be and where it's at.
Yeah.
And where it might go.
My wild hair, where this started in 2014, almost got replicated in Wyoming last season. I was going to go get this articulating stepladder, plop it over two corners, and then I knew which landowner, very wealthy, out-of-state landowner, billionaire. I was going to call his ranch manager and say, hey, tomorrow morning is opening day of hunting season. I'm going across the corner here, so if you want to bring the sheriff out. And I was going to pick this specific county because the district attorney was known to be a very aggressive prosecutor of anything related to quote-unquote trespass. So I went to another law firm who you all know, that had settled our stream access case here in Montana.
Yeah, great lawyers.
Yeah. And they gave me some opinions. They're like, now, Randy, we want to see the public get access to their land. But I was under this false premise that if I went there and I won, the whole world would be changed. And so they're like, now think about this and think about that and think about this. So it was one of the most useful attorney fees I've ever incurred. Second only to the fees I incur at this firm.
And the free advice from Buzz.
Yeah. But so 2014 is when that happened. And so I've been trying to find ways to solve this within the law. And one of the things that was pointed out to me in 2014, and we'll get into this later, I hope, they told me, they said, Randy, you can go do all this, and let's say you win. The greatest outcome, it's like summary judgment in your favor. Guess what's going to happen? I'm like, what? They're like, the Montana legislature is just going to go and change the law. I'm like, what? They can do that? And they're like, well, yeah, that's why they convene for 90 days every 2 years, is to change laws like you might punch a hole in. I'm like, oh, man. So it really set me back in my thinking on this. I would say it put me forward, but it set me back in thinking this could be solved tomorrow. So with all that, as I've used the services of your firm for however many years now, and Nick, you've been helping me on some public land things unrelated to this discussion for 2 or 3 years now. I've been working on that. As these topics would come up, you guys were giving me some really good free advice. I said, well, I need to hire these guys, so then the advice is going to be even better.
Even better.
So with that, you guys have been helping me over however many months now, and we've had multiple meetings. We've brought in some what I'd call real, star power minds who've afforded us the benefit of leaning on them, professors and others who write in this stuff. And now I feel that we're to a point where we can at least talk about these issues as it relates to the topic at hand. How do we legally get access across corners, legally and without claim against us by adjacent landowners? And I'm going to let you guys go from here, because an accountant talking about the law is like an attorney doing their own tax return. No offense, guys.
Right. One thing I would say, Randy, is a couple of things. We are talking about crossing corners in the checkerboard.
Yep.
That's the basic thing we're talking about.
Right.
Where you've got like 4 corners together, 2 public, 2 private, diagonal from each other, stepping from one piece of public land across the corner to the other piece of public land and not touching private land.
Exactly.
And maybe before we begin that discussion, I think you have more information than we do. You ought to tell us how much land we're talking about, because when you say you can't cross at a corner, public land to public land, you are saying this public land is not available to you, Mr. Hunter or Ms. Hunter.
Right.
So how much land are we talking about?
Not counting, so there's 2 pieces to that. There's where they touch at the corner, and then there's the completely isolated landlocked stuff.
The end holdings,
Yeah, so we're not talking about the isolated landlocked in holdings. That's a much bigger number when you add. So you take that and you add in the corner crossed or access that could be obtained via corner crossing, and you get an even bigger number. But some of the estimates out there right now are there's about 1.6 million acres in the West of federal land that access could be obtained if we were allowed to cross diagonally at corners and have the public go enjoy the public land.
Right. And is it true that at those corners, most of the time, the private landowners do not want you to cross public land to public land? Is that the case?
I would say 99% of the time. I don't have a certain percentage, but in places where it exists, there's some landowners who are like, you know what, it's your land, go do it. Just, cross at the corner. Don't be crossing 100 yards over here, 100 yards over there. But with the trend of what I call the new age landowner, who's coming to Montana, Wyoming, Idaho, Colorado, they're bringing with them their land ethos of where they came from. And these are billionaires, or at least, whatever the term would be for someone who's worth, hundreds of millions. And they're accustomed to getting what they want. And they don't really care that, the former scratch it out rancher used to let people cross at the corner. They read a real estate ad that said, 3,000 acres, buy it for this, and control access to another 8,000 acres. Or sometimes the numbers are 10 times what I just stated there. So it just is a trend that is happening more and more and more. And so we're at, 1.6 million probably is on the conservative side of land that could be accessed.
And that would be 1.6 million acres that is owned by either the federal or the state government, right?
Yeah.
And is there for the enjoyment and use of the public.
Mm-hmm.
And the public cannot access it.
Right.
And so the private landowner who may come from an out of state, buying a big ranch,
Right.
is able to use that land for gathering huckleberries, shooting elk, moose, whatever might be there,
Right.
while at the same time forbidding the public from accessing just that property, not walking on private land,
Right.
but public land.
Yep, exactly right. You painted the picture. And I'm sure some of you listening might be saying, well, why did the federal government let that happen? Well, in the 1850s, most of this was given to railroad companies, where for, some 5 or 10 mile swath either side of their rail line, they got every other section.
Yeah, the checkerboard.
Yeah, and it really is, instead of a black and red checkerboard, it's a white. If it goes through BLM, it's white and yellow on your map. If it goes through Forest Service, the white is private and the public is green. But yeah, true checkerboard. So it's not like the federal government currently has said, oh, this would be a really cool problem to create.
Yeah. No, it came out of historical circumstances, like you said, prior to the Civil War and then into the Civil War, where the United States government was trying to figure out how to get railroads out across the continent. They couldn't get anybody to invest because it was too risky.
Yeah.
And so they came up with the scheme where they'd say, well, you get every other section if you're going to build the railroad. And then, on down the line of title, railroad companies sold those to timber companies, sold them to, subsequent private landowners. And now you have this checkerboard pattern, like you've described, the green and white, or the yellow and white, typically, what we're talking about. So it wasn't something that the Congress, the United States Congress at the time, appears to have really given a whole heck of a lot of thought to what it would look like in 150 years down the road.
Well, but there are in some cases discussions by courts who talk about what Congress talked about when they were creating a checkerboard. And it's clear the government thought, and what it says are two entirely different things. But the thinking was that the railroads would make a lot of money from the land they owned in the checkerboard as towns developed and things like that brought people into where the train stopped. But that correspondingly, these public land sections would increase in value too. And so the railroad would make some money, and the government would get a return on having given away these millions and millions of acres to the railroad.
Yeah.
And they could develop in tandem, kind of like you see back east of the Mississippi. And access would not be a problem. Nobody really thought about, I think, access being a problem.
No.
And they just developed, but that didn't happen. And there are a million reasons why: cattlemen, sheep wars, range wars, things like that. But then over time, when access did become an issue, the problem begins to rise up, and it wasn't expressly addressed back when the checkerboard was created. And now there's a raft of what we'll probably talk about in this conversation, Randy, of laws, state decisions, federal legislation that go toward addressing this issue.
Yeah.
And it's on its way to at least a resolution in one small piece of Carbon County, Wyoming right now.
Yeah.
Whether you can cross from one piece of ground, public ground, to another.
Yeah.
But that's going to be a decision of one case in Carbon County, Wyoming. And what effect will it have on us in Bozeman? Zip.
Yeah.
What effect will it have on the next county over in Wyoming, legally? Zip.
Right, unless it moves up some appeal process. The higher up the appeal, the greater the expanse of the decision. Am I right?
That's generally the way that I can't speak specifically to the system in Wyoming there for appeals, but you always have the lower courts, district courts typically, and then you have what are called appellate courts, So that's, the most famous one that we think of is the United States Supreme Court. That's the highest court in the land. But all the different states have their own system of state courts and state appellate courts. We have that in Montana, district courts, and then we have the Montana Supreme Court is our, final appellate court. So Wyoming also has a Supreme Court. Depending on what happens with this case in the district court in Wyoming, it may end up later on in the Wyoming Supreme Court, and what the court does there, who knows. But that would, just as a general proposition, potentially set a precedent for the state of Wyoming in that Wyoming Supreme Court.
With similar facts and circumstance.
They would be court would be considering the same facts from the underlying case.
No, but that's a good point, though, Randy, because if this Carbon County case pending right now gets appealed to the Wyoming Supreme Court and they make a decision, that would be a decision based on the particular facts in this case right now. And then something else could come up that's different.
Right.
And different facts can lead to different results. People sometimes tear their hair out about that, saying, hey, here's the precedent. But facts are crucial. They make all the difference in the world. Different facts, you might have a different result.
Yeah, I agree.
So over the course of this, we'll probably touch on the case in Wyoming, which, it's kind of weird. I started on this project so long ago, having no idea a case in Wyoming would pop up while we're talking about this, but it's a good case to follow. I think it's raised the awareness, and personally, I hope they win. I hope they prevail on every count.
The hunters,
but I had no idea that case was out there when we started talking about things. But here it is. So we're going to make reference to it at times. But I want to talk about some of the basics because I'm not an attorney. I get to read tax law. That's like as dry and boring as anything in the world. That's and I'm not even licensed to practice tax law in front of a court. So I don't want to be the one adding some of this. And it's been 36 years, I think, since I took my year of business law. I didn't take any criminal law. So I'm hoping that you guys can lay some basics here that are really important to where we go with this discussion. Things in my mind are the priority of law. Tom, you already touched on precedent. What is the priority of law? Is it case law? Is it legislation and statute? Is it, where does that go? I want to talk about the difference between, because this is one thing I did not know of until I hired the firm in 2014, how much distinction there is between civil and criminal. I just this oblivious American thinking that, that's, don't worry about that. But this case in Wyoming, now it started as a criminal case. Now last week we see here's a civil case brought forth against these 4 hunters. And whatever other principles, doctrines, ideas, myths that you think are applicable to having an in-depth discussion in this, because we're going to get into a bunch of court cases that you guys have looked at, that you've researched, kind of all the rabbit holes where those cases take us. And I think it would be helpful for people to have some understanding about just these basic premises that all this is built on. So I'll let
Nick's real smart.
Tom points to Nick.
And we can,
I'll go ahead and explain our whole system of law.
Yeah, why don't you take a crack at some of it, and I'll
should
chime
only
in.
need about 30 seconds. So I think that's a great question, Randy. Just to go back to absolute basics on, our what you call the priority of laws, which I'm, interpreting to mean, what law controls over what other law? What's the one that has the final say?
Right.
So we have in this country, there's our bedrock is our federal constitution. The states have their own state constitutions. There's a general principle that the federal law is supreme over the state law, where those two conflict. The federal law is the one that's going to control. This is very broadly stated. It's a lot more complicated. And then you have legislation. So you have the Montana legislature passes laws, the governor signs them, and they passes bills, governor signs them, they become laws. You have the same thing happen in the federal government. Our U.S. Congress passes a bill, it's presented to the president signs it, it becomes law. And then you have the court systems. Okay, well, what's their job? Their job is to interpret what the laws mean. So you have statutes out there, and a dispute arises under a statute. It's criminal or civil, either one at this case. And the parties, folks who are in the dispute, go to the court, and it's the court's job to decide what the law says.
And how it applies.
And how it applies.
On the specific facts.
Like Tom mentioned earlier, on these specific facts. And that's a huge piece of it. And the courts can do some, from time to time, pretty radical things. They can say, hey, this law that you passed, U.S. Congress, is contrary to the Constitution, so we're going to invalidate the law. Same thing can happen in the state system. Mm-hmm. Say, hey, this law is contrary to the Constitution. We're going to invalidate it. That's not something that happens very frequently.
Yeah.
But typically what happens is that the courts are tasked with the problem of, as Tom said, applying the law to specific facts that are presented to it in a way that is consistent as much as can be made possible across the spectrum of disputes that arise. So that's the statutory system based in the Constitution, and it's the court's job to interpret those. There's another piece of it, maybe Thomas talked about, called the common law, which is distinct from laws that arise from the statutes.
Right. Yeah, the common law actually developed in England, and it was just a series of court decisions about what the law is or how the law works. And when states came into the Union, like Wyoming and Montana, when they came into the Union, they adopted the current English common law.
Yeah.
And then a court decision now changes the common law, like in a contract. If you don't have a statute that applies and a legal dispute arises, court makes a decision and articulates what the law is. That's the common law. That's kind of esoteric. It's not governed by a statute. But to go back to a point Nick was making, one distinction I wanted to draw is that in states you have civil law, which can be the common law or statutes that regulates behavior. A civil trespass. I drive my car onto your property and I tear it up and I don't have permission to be there. The owner has a civil claim against me. I trespassed on his land and damaged it. And he can sue me for money in court. That's a civil claim.
Right.
Statutes apply to that kind of trespass. And there's also some basic common law about trespass. A criminal trespass is different. When you get in a criminal case, that's not me as a private landowner suing you. That's you doing something that the statutory law, the state criminal law says that's a crime. You're prohibited from doing that. And those violations are policed by or handled by criminal courts.
Okay.
It's not a private landowner there. It's the state saying you violated a law in our books, and here's the penalty.
And a sheriff, a police officer, someone's going to come and issue you a ticket? Or arrest you? Or
give you a ticket or arrest you. And then if you say, hey, I didn't do anything wrong here, or if you say, I plead not guilty, you have a criminal trial with a jury in front of a judge. And the decision is they decide if you violated the law. First of all, they can say you didn't or you did. And then there are guidelines, statutes again for sentences, fines, and things of that sort. But it's an important distinction.
Yeah.
And not to bang in this Wyoming case, but they're both types of claims are down there.
Yeah.
The Carbon County District Attorney or County Attorney, whatever they're called, has filed charges against those hunters and saying you violated the criminal law, and if we find against you, we can either send you to jail or fine you.
Right.
And then the ranch owner, as I understand it down there, has also said, you trespassed on my land in a civil fashion, and you're not allowed to do that. And in that private civil case, he can get damages, he or she can, if they approve that you've done that. So that's a distinction that's important, I think, here.
So in criminal law, the claim is brought by the district attorney.
Really, by the you can say it's the state.
Yeah, whoever the
Whatever officer of the state is doing it, it's
agent of the
coming
state.
from the state.
Whereas a civil claim is brought forth by the damaged party.
That's exactly right.
So there's
Exactly
a distinction there that in a civil claim, you got to do your own heavy lifting. You're going to incur your own attorney fees.
Yeah.
In a criminal case, you almost have an agent when you pick up the phone and say, hey, someone's trespassing on my land, write them a ticket for trespassing. You now have someone representing you. It's kind of, you aren't incurring costs. It's not your headache to some degree.
The state has decided that what you did is a crime. And now the state has to prove that it was a crime and punish you. The landowner doesn't have to do anything except testify. Yep, Bob was out here churning up my land. And he committed a crime.
And I'm sure that in your practice of law, your reading of law, the discretion prosecutors or district attorneys or the state uses probably is somewhat inconsistent among who that prosecuting person is. Would that be safe to say?
Totally.
Where a DA in one county might say, this isn't worth our time. This is so minuscule. Whereas someone else might say, these sons of bitches who do this stuff, they drove across my lawn one time too, and I'm going to show them.
Yeah,
I there
think
that
that's
individuality sometimes?
I think that's true, and I don't really do much in the criminal field, so I don't want to get too far out over my skis on it. But that's just a piece of human nature. Is that a prosecutor or county attorney or something like that? They do have discretion, and how they exercise their discretion is going to depend on what they're prioritizing or what seems most important to them. And of course, you see that when folks run for these type of offices, because they're often elected offices, and they'll have a platform or a plank. They say, we're going to address the meth problem here in Montana or here in whatever county you're at, that type of thing. So it really I think does come down to everyone's bound by the law, but there is discretion that prosecutors have when they decide whether they're going to bring something or not.
Yeah, and you can put a little finer point on it. What typically happens is somebody engages in some kind of behavior someone thinks is a crime. There's a complaint made to the law enforcement agency, the policeman, sheriff, folks like that. It's investigated. A report is made by the police to the county attorney saying, Bob did this. We went out and investigated. Here are the facts we found. And we arrested him on thinking he committed these, let's say, 3 crimes.
Yeah.
And then the county attorney looks at that, and that's where the discretion comes in. It's actually more than just kind of a mental idea. It's a fundamental principle in the law. A prosecutor can exercise his or her discretion and either say, okay, I'm going to file a claim against Bob, try to convict him of this crime through a trial, or I'm just going to let it go this time. And that's where it all begins, is at that level. It's a fundamental concept in the law, but it's prosecutorial discretion. And I know personally there's some prosecutors who have dealt with corner crossing complaints and said, you know what, I'm not going to make a federal case out of this.
Right.
And others will say, I think this violates criminal statutes, and we're going to prosecute them.
Yeah. So criminal statute is very dependent upon that state's statute. What might be considered criminal whatever in state A might be not covered or not considered a crime in state B. It's not
That's
like
totally true.
Not like we have a common uniform criminal statute in the United States.
Not between the states. There are, the federal government does have some criminal statutes. The jurisdiction is a fancy word for saying the limits of the government's power. In the federal government, with criminal actions is more limited than with the state governments. So there's not as many those federal laws although they, there's quite a few, but the states really have what's called the police power. It's pretty broad. It's not just about criminal issues, but yeah. So the states set their own criminal codes. There does tend to be overlap or resemblance between the different states, because over time you get, for instance, I think maybe the Bar Association, American Bar Association, they'll put together model criminal codes or penal codes for certain issues, and states might adopt those, and so end up having similar statutes. But the short answer to your question is, yeah, it can vary state to state.
And it does. And one point that underlies this, Montana could say, and I'm just making this up, and it's kind of silly, but Montana could say, if you wear pink trousers, it's a crime.
Yeah.
And then Wyoming could say, if you wear brown trousers, it's a crime. Pink, okay. Brown, not. Yeah. I mean, states have a power to say what's a crime, and there is no common law of crimes. Crimes only exist because statutes say this behavior is a criminal offense.
Okay.
The statute has to spell it out. No common law of crimes, and they can differ from state to state.
So every state has an attorney general. Do they have any role in any of this, or is that later on if it gets to a higher level, or is that the attorney general issuing an opinion about certain things within that state? I mean, we don't hear much about them in these property cases or in trespassing or anything like that.
Yeah, their role is, not to jump in, Nick, but
no, go for it.
The AG's role is pretty modest.
Okay.
They control law enforcement, things like that. I mean, they oversee it, but they're not passing statutes. They can decide at certain times, states, they can decide on behalf of the state, we're going to prosecute some action as a crime, subject to certain rules. But they're really more in the background, would be my view. Nick may disagree with me, but my view of it, they're more in the background there. They can be a loud proponent of certain actions, wanting prosecutors at the county level to prosecute certain behavior, but they're not nearly as powerful, in my view, as legislators are in enacting criminal statutes, or really county attorneys in deciding who they're going to prosecute. The AGs have the power under statutes to prosecute. They're the ones who decide to prosecute certain crimes within the state.
Mm-hmm. But like what we're talking about in terms of a specific, say, trespass action in a specific county, then that is going to fall, I think, generally to that county attorney.
Yeah.
That's their job to figure out, whether they're going to, try to prosecute that or not. And I think Tom is probably right about the general assessment that the AG, or the Attorney General for a given state, is probably not doing what we'd call the line work of those individual prosecutions.
Okay. Well, that explains then why we don't hear about them much in these kind of cases. It's like, are there even attorney generals out there? We know we vote for them every 4 years. But,
yeah.
So now with that, there's one more thing I want to touch on, and maybe this is or isn't the time. You guys tell me when it's a good time to bring it in. But when I buy real property, or I own real property, I'm selling 20 acres tomorrow. Actually, I am. So there's a good example.
All right.
What do I own that I'm selling? And what is the buyer getting with that deed that I'm going to sign tomorrow? In other words, this seems to be a little bit at the crux of, do I own everything below and everything above? We see maps where it says, there's a split estate. The surface right is separated from the subsurface right. It's like, do I really own all this? Do I only own part of this? Or is that too broad of a question?
Well, the best lawyer answer is it depends.
Yeah.
That's how accountants always
But the
ask
thing
also.
is, to wrap up all the concepts of property and the bundle of rights that's in there
Right.
probably takes about 3 sentences. Take it, Nick.
There we go. So we think about as lawyers, and we're taught this way. Think about your rights and property as a bundle of sticks.
Right.
That's what they teach you in law school.
Yep.
What does that mean? It means that when you own a piece of real property, a piece of real estate, you have rights associated with that ownership, and you may have some, you may have all. It really depends on what you get. Some of the real fundamental sticks in the bundle that we think about, that really we think of as sort of common sense, are you have the right to use the property.
Mm-hmm.
You have the right to exclude others from the property.
In certain cases.
In certain cases.
Yeah.
You have Tom makes a good point. None of these are, in the state of our law today, these absolute statements. These are
Okay.
just speaking generally.
Mm-hmm.
So you got the right to use, you got the right to exclude, you've got the right to have the benefit of whatever you can grow on the property or sell off of it. You may have the right to the mineral estate, what's under the ground. That right might belong to somebody else.
Right.
You can have of course, importantly, the right to sell it is another right in property.
Mm-hmm.
So there's this whole big bundle of different property rights that you can have depending on what your deed says, and that's why I say it depends.
Yeah. But one thing I was kind of making a joke when I said, take it, Nick, 3 sentences. Concepts of property evolved in England that bind us, and they started coming into play in the 12, 13, 1400s as feudalism ended and private property ownership began.
Okay.
And people have written about it, Randy, and there have been cases about it, treatises about it, that have been written back in 16th century England, 17th century England. They are law review articles today are full of articles about what property is, how it can be used, what the rights are associated with it. What's the difference between ownership privately and ownership by a government? If a government owns land and the public owns it, what kind of rights do they have versus a private landowner? It is a huge area of the law, and it's not static.
No.
It's probably the most important thing in this conversation. It
changes all the time?
All the time, over time. As new situations arise, new facts arise. So I think we'll find, like in the Wyoming case, the private property owner has an absolute view about what private ownership means.
In their mind, they're saying, "This I own everything."
Mm-hmm. And I didn't mean to interrupt you.
No, I was just adding to that's in Wyoming. That's how this landowner is, and kind of is the point I'm trying to get to is, what do they own? Well, they think they own everything. And by everything, I mean, what you guys like to talk in these Latin terms.
Well, if we're talking about the air, which I think we're going to be talking about, because
that's the premise of what this Wyoming claim is based on.
There's a commentator, a famous judge and commentator in England named Blackstone, who was talking about what property rights. I mean, private property is a very fundamental concept in our world.
Yeah.
And he was saying, from a legal standpoint, if I own an acre, I own it to the center of the earth. And I own it to the end of the universe in the heavens forever. That's my acre, and it's mine and nobody else's.
So everything from the core of the earth, which when you get to the infinite little core of the earth, there's not many acres there.
But it
gets pretty small.
It gets down to it, kind of like a piece of pie.
Yeah.
And then as it comes up, it includes your acre of land at the Earth's surface.
Everything to the end of the universe.
To the end of the universe.
So
that's Blackstone. And that was an English concept.
Back to like
1700s.
I think, you correct me if I'm wrong, but I think there's some of the origin in that even goes further back to almost Roman times in the Code of Justinian. This idea of and you mentioned a fancy Latin phrase, Randy. It's sometimes referred to as the ad coelum doctrine to the heavens. Ad coelum. And as Tom mentioned, there's Blackstone, the famous commentator, talking about that. But this idea, generally not to jump ahead, but the idea that you own out to infinity and down to some mathematical point in the center of the earth has been a long time since anyone, a judge apparently, at least that I've seen, took that idea at face value.
Oh, in other words, they're like, you can say that, but come on, let's be real here.
Well, there are two ways of looking at it. One is, come on, let's be real. I mean, you hear that phrase most often by people who own at least 45,000 acres of land in the West. I'm serious about that.
So there's a selective choice of who uses that doctrine?
If you own a whole bunch of land, you're really in favor of that.
Yeah.
If you're a hunter trying to get a deer to feed your family and crossing at a corner, you don't feel that way. And I don't mean to be facetious about it, but that doctrine really doesn't apply anymore. There's a U.S. case early on as airplanes began flying around, right? And landowners were saying, dude, you're flying across my land at 30,000 feet. You owe me money or you're trespassing.
Right.
That all ended with legislative acts and Civil Aeronautics Board and things like that.
Yeah.
But the federal government, there was a case that described this. And here's a quote from it. It's a case called U.S. versus Cosby, talking about this ad coelum doctrine. It is an ancient doctrine that at common law, ownership of the land extended to the periphery of the universe. And then they go on to say, but that doctrine has no place in the modern world.
So
it's gone.
There's a case, you guys have given me multiple cases that challenge this theory that you own all the airspace above.
Or even 100 feet of airspace above.
Yeah. And, the states and the feds sorted something out, who had power under the 10th Amendment. And we're not going to get into that just to say that's been sorted out.
Well,
to some degree.
To some degree.
Okay.
To some degree. But who owns the air is a real difficult question. It's not addressed. There's a federal case that applies in Montana, Hinman versus Pacific Air Transport, but and in that the court said, an owner of land, it says the right to airspace is not fixed. It says it varies with our very needs and is coextensive with them. The owner of land owns as much of the space above him as he uses, but only so long as he uses it. All that lies beyond belongs to the world. So just think about that.
You guys read these to me, and I'm like, wait a second, how the hell can this be? So
that's what a court said. Dick and I are just sitting here bumps on a log. We're telling you what a court said.
No, I get that. So I'm thinking in my head, the premise or the claim made by, if we refer to the Wyoming person or the people who threaten, if you do that, I'm going to, I'll sue you or I'll get the sheriff out here. They are holding absolute strong and fast that this ad coelum
to the heavens,
to the heavens,
to the heavens.
That applies, and I own this airspace.
Right, and for those hunters down in Wyoming who never touched the surface of land, but went over airspace on a ladder and were 3 feet above the ground and encroached 1 foot onto one piece of private land and 1 foot on the other. They're saying, that's a trespass. The owner is. That's a trespass. And
so you said 1 foot on private and 1 foot on another. You meant 1 foot on public, another foot on public.
No, I mean, they extended their hips.
Oh, I got you.
1 foot in the air. Right, on one side of
swung
1 foot.
over private.
Swung over private. That's the argument.
So the argument or the premise that the DA or the landowner in a civil claim is making is this doctrine applies, and therefore you have violated, for a civil claim, you've violated my property right, and I can file for damages. Or the DA says, by doing that, we believe you've committed the crime of trespass by swinging your foot over. And they're basing it all on this. Am I safe to say they're basing it on the premise that this doctrine defines what property rights that landowner has?
I think that's, I might modify it a little bit, just because we're not talking about being 30,000 feet up in the air. We're talking about being, closer to the ground. So they don't have to say, hey, we own this thing all the way up. But they are saying there's a point where there's 4 different lines that come together. There's a vertical plane that goes up from that. And to get over that point, you have to go through this imaginary plane to go from public to public. And that's in the air that's above our property. And that's a trespass.
And we own the air.
And we own that air.
That's the claim. That's the premise, the basis for, because a lot of my audience, myself included when I first started in this, was like, wait a second. The person owns the dirt. I get that. I'm not stepping on their dirt. But they are making a claim that, Tom, you've already cited 2 cases that seem to say, wait, this this is as much legal fiction as some of the other stuff. So but for the listener, if we say, here's the rationale, whether we agree with it or can punch holes in it, the rationale being used by the DA and now the landowner who's filing a civil claim is based on this premise.
Yeah, I think that's accurate.
Okay.
That's right. You encroached a couple of inches into my airspace. And now you should go to jail and pay a fine. Although you never touched the surface of my land.
Right. Well, the reason I still laugh out loud when I hear this is because it doesn't pass the laugh out loud test.
Right.
I mean, you read all these cases where these say it's not public at adjacent corners, but there's places where it's private at adjacent corners, or it's private at adjacent boundaries. And they sue each other over this stuff all the time. And when it's trying to exclude the public, they're saying this doctrine applies. But when they're trying to extend their rights to somewhere else, they say, wait a second, that doctrine, it doesn't apply. It doesn't apply here.
That is totally true. Totally true. And Nick and I have looked at this stuff a lot, and there are a lot of law review articles about it. But what is the wild card in what we're talking about is that not only that, like, hey, dude, you're bruising my airspace, right? That's one thing they're saying.
Put it.
Yeah, but the other is, what about the rights of the public?
Yeah.
In these corners?
Right.
Because the private landowners can walk across their boundary onto public land and pick huckleberries, hunt, shoot elk and all that. But if the public wants to do the same thing and just cross over in the airspace in these checkerboard corners, all of a sudden, whoa, you can't do that.
Yeah.
Who thinks about what the public's rights are?
Yeah.
Or if the federal government or the state government owns this land for the public, what kind of rights do they have as property owners? Because they are sovereign property owners too.
Right.
That affects the rights of adjacent private land holdings.
Yeah.
And that is a huge topic.
Really?
Oh, God, yes. I mean, there's all kinds of law about, the federal government has the constitutional right to pass laws and deal with the property as they want to, as a sovereign and as a private landowner. And
really?
So, oh, yeah. And so, if I'm a private landowner, I've got limitations on what I can do and how I can use my land, and it affects others and vice versa. But in all these discussions of the ad coelum doctrine and things like that, private landowners are saying, I have an absolute right to these rights. And they never think about, and we can talk about in this podcast, what are the rights of the public in the land they own that a private landowner is trying to keep them from enjoying?
Yeah.
It's a huge thing.
I mean, there are people who say that the federal government does not have the power to own land.
They're wrong.
Yeah.
It's in the Constitution. It is in the Constitution. Actually, we found a cite to it because Nick and I found an old dusty copy of the Constitution. We hardly ever read it. And let me find out where it is. It's in Article 4, Section 3 of the Constitution, the U.S. Constitution. Congress has the power to dispose of and make all needful rules and regulations respecting property belonging to the United States. That's what it says.
Okay.
And that has been interpreted by U.S. Supreme Court after U.S. Supreme Court decision as saying the government can acts as a sovereign, which is different than a private landowner, with respect to its land, and as an owner.
So the guy who walks around with his little pocket version of the Constitution with 3 pages tore out,
he might not see it.
He's another one of those laugh out loud kind of guys. It's hard for me to take that person serious.
Well, it's worth reading the whole Constitution. I'd say that.
Good point. Good point. Not just the odd numbered sections.
The whole thing's in there.
So there's been cases out there that talk about what and most of these, I think, apply to federal government. We probably won't have time to get into some of these that apply to state government action or state statute. But you guys have looked into a ton of these federal laws and how they apply in these cases, where they were applicable to what we're talking about here. Not all of these corners are fenced in. Excuse me. But a lot of them are. And I showed you guys the pictures of the corners in Wyoming. Mm-hmm. How they
on that ranch.
They almost like built a little steel wall with metal posts. And I've seen others in Montana. I've seen them in other states. And you guys looked at that, and the first thing you said is, well, under the what is it, Unlawful Enclosures Act or something.
Listen to you talk like a lawyer. Yep.
Well, I'm bringing this up because you guys pointed it out to me.
You got it right. Yeah, you got it right.
That you can't, under that law, you can't deny the public in certain instances. I don't want to say any more than the term Unlawful Enclosures Act because I'll mess it up.
Yeah, well, let's talk about that a little bit. Probably the best place to start with it, like we have with other topics here, is at the beginning. It's an old law. It's from, I think, 1885, but it's still good law. It's still on the books. It hasn't been repealed. And the reason that it was passed is, as we understand it, is during that time period, you had in the western part of this country this great push to bring cattle in, sheep in, and also homesteaders coming in. Mm-hmm. And there was fights all the time about who would get access to what lands, what was then called the public domain, or public lands that you could settle and claim under the laws at the time. And what cattle operators figured out is that if you got to a good patch with water, that'd give you control of a lot of the surrounding area because, out here in the West, it's not like the eastern part of the country. There's not that much water. Yeah. And so you end up with these de facto kind of control of all this land that belonged to the public by private operators. And people were killing each other over it.
Yeah, the Johnson County Range Wars.
Yeah,
in Wyoming.
Yeah, so it's we watch movies about it now, but so the Congress steps in and says, well, we gotta fix this thing. And so what this act does is says that it's illegal for a private landowner to prevent or obstruct the free passage to the public lands, and that's been applied to fencing. It's been applied to like actual physical threats and altercations. But the general purpose seems to be that Congress had was to try to resolve this problem of private landowners blocking access to the public land.
Mm-hmm. So it can be physical threats, not just mechanical structure.
Yeah.
It can be all kinds of things that create a problem or a violation.
Yeah, the language of I'll just, read from the statute itself. There's language in there that says you can't use force, threats, or intimidation to prevent the, peaceable use of the public lands. And I'm paraphrasing there a bit, but there was, if we jump into some cases, I guess there's an interesting case where there was a sheep herders trying to move sheep across this big stretch that was had been used from moving from one range to the other range, and so they're crossing over some private, and the cattle guys come out and say, "Hey, you can't do this," and end up actually shooting one of the sheep guys. I think is the facts on the case, and you can't do that. Turns out.
Yeah, to put a finer point on.
I mean, you're not just that you can't shoot somebody, but you can't use that level of force and intimidation to keep them from
crossing through that land.
Yeah, the statute is worth reading. It's got a couple of sections. One particular section deals with fencing.
Okay.
Because in cases we see cattlemen, think about the checkerboard again, the cattlemen would build a fence right up on the line of the private sections.
Right. So just off the public, but...
Just off the public, but it would keep sheep herders mainly. It's cattlemen versus sheep herders in these early cases.
Okay.
But you blocked off passage because of these fences on, think of the checkerboard where the private land is. If your fences go right up to the border, you've got a wall.
Right.
You could wall off, and one guy walled off basically a whole township, 36 sections.
Whoa.
So he had 16 private or 18 private.
Yeah.
Yeah, and then 18 public.
Yeah.
And this statute says if you just put up this fence to keep people from accessing public land, you got to take it down. And the court has ordered a number of ranchers from this case. This is the Camfield case in 1897. But beyond, up till current times, Randy, saying, hey, you're putting up fences, and it's not for any reason other than keeping the public away from public lands. So that's one aspect of it. The other that Nick mentioned, there's a Section 3 of the statute that says you cannot use force, threats, intimidation, or any fence, enclosing or otherwise any other unlawful means to obstruct any person from peaceably accessing public lands. And there's a case, and this should strike fear in the hearts of big landowners who are trying to keep the public out. There's a case that criminalized that behavior when people tried to sue people. Well, landowners trying to sue the public from accessing public lands. They said that's a federal misdemeanor if you do it.
If you violate this statute?
If you violate this statute. If you act unlawfully, threats, force, and intimidation include trying to make a claim of trespass, which is a stunning case when you think a stunning case. But that's been used when people come on the land and say, I own this checkerboard. You can't cross this to get to your grazing land because some of it's private. Yeah. Here's a gun. Cross and we'll shoot you. Yeah. That's a federal crime. Standing up there with a big guy who's got big muscles and saying, my friend Bob is going to pound you to pulp if you bring your sheep across. Really? Yeah. Really? That kind of threat is a federal crime. And these fences that you're talking about in the Wyoming case, these little dinky fences, the only reason those are up there, one could argue, I'm not saying it is.
I've driven by this spot. I've seen these signs with my own eyes. I've seen the posts. It's not like this is a long stretching fence.
No.
It's specifically at the corners.
Right. And there is an argument that Nick and I have talked about a lot that says when you put stuff up like that saying no trespassing, in other words, I'm going to call the sheriff, if you cross at this little corner, there's an argument to be made that violates the Unlawful Enclosures Act. And there's an argument to be made that if you own 50,000 acres of land and don't live in Wyoming and try to throw people in jail, get them thrown in jail by putting up those things, that is a federal crime, a misdemeanor.
So who is, let's take it to the next step. We're not talking about a mythical, like, what if scenario. We're talking about scenarios that are out there on the landscape right now. So I encounter this. I'm like, hey, this person is obstructing me from accessing public land. What can I do about it? I mean, if I can't get the BLM officer or the Forest Service LEO to do something, I may as well just stand out on the street and yell.
Yeah.
Well, there's an officer, a federal officer in every state called the U.S. Attorney.
Yeah.
Right? And this Unlawful Enclosures Act says, and Nick caught this and pointed it out to me, that if you feel that you are unlawfully being deprived of your ability to access public land, you complain to the U.S. Attorney. You give him an affidavit. And the U.S. Attorney investigates, and if they feel that the landowner, the private landowner, is violating the act, he files an action against him. The U.S. Attorney files an action against the landowner claiming he or she is violating the act. And if it turns out they're violating at least Section 3 of the Act about unlawful force, threats, force, that is a federal misdemeanor. And two things can happen. Number one, the landowner can be convicted of a federal crime, a misdemeanor. And number two, the obstruction comes down or stops.
Yeah.
Now, does that apply in the Wyoming case? Who knows?
Yeah.
We haven't analyzed those facts, but it is a big stick that's out there for any private hunter or person who wants to access public land to use.
So why don't we know about this stuff? I mean, has there ever been a U.S. attorney brought forth a case under the Unlawful Enclosures Act?
Yeah. Here's the thing about it. Yes, why don't we know about it? Well, most of these the cases that we're talking about are old. Like these are cases are 100+ years old. Okay. And they really go back to that era of folks trying to fence out the public so they can have this. It's the same kind of thing that we're talking about now, but it's in the context of cattle and sheep and that type of thing. Okay. And so there are cases where the U.S. attorney for a state has brought a claim. And the one I think Tom mentioned it earlier is the Campfield case. This is from I think it might be 1897 maybe. Yep. And that's the one where he described this sort of ingenious pattern of fencing just inside the private the boundary, but effectively securing the entire township, so that they had the exclusive use to that. And that's where the United States Supreme Court, so we're going there back to our initial discussion of, which courts have the biggest say in interpreting the law. Well, for the federal law, it's the United States Supreme Court.
So this Canfield case was a U.S. Supreme Court case?
Yeah.
Okay.
Yeah.
A big one.
And that's where the court said, hey, you can't, just because you put the fences up on your own property doesn't mean that this act doesn't apply to you, because what you've done is you've obstructed the public access to every other section in the township. So it's not just about regulating what can happen on those federal sections. It's saying you can't use your private property to obstruct access to the public land. And that was a case that was originated, as I understand it, as a criminal prosecution. So that's they talked about the role of the U.S. attorney in there for whatever given state that you're in. And
one thing that happened too, Randy, is that these cases were the range wars, right? Cattle versus sheep. as and this has really affected property law and what public property. As time has gone by, sheep and cattle have been more confined, private land, ranches. But what's really happened is the BLM and the General Land Office sold off as much U.S. property as they could.
Oh,
right?
yeah. Lots.
And the best stuff got bought. And they were left holding millions of acres. The government was.
Right.
And then the government made a change and decided, you know what, we're going to manage this. We're going to keep some of this in public land ownership. And you had things like Forestry Service, logging. You've got the Interior Department. You had a number of policies and how you use it, drilling for minerals and oil and
Right.
things. And over time, too, you have had a development of, through extraordinary work local game departments have done, we've maintained our wildlife, right? And then, so we have mainly through federal government policies, really encouraged and promoted hunting of game. So you can go out and get your elk on public land, and you don't have to go on private land for it. And they've really helped preserve and promote hunting, and then foraging, berries, mushrooms, whatever. And over time, what's happened is public access, general public access by guys like Nick, who skis over public land way in the back country, and me, who goes out and wants to pick a few huckleberries.
Yeah.
We're big appreciators of this property because we can go onto public land and roam around and do what we want to do. And so recreation also became a huge thing. And that's in current times, and that really puts pressure on answering this question of what kind of access do I have to public land when a private landowner is trying to keep me out? And there are more and more and more people who say, how do I get to this public land to use it? I don't want to hurt a private landowner,
Right.
but I sure want to be able to access public land. And as that happens, more and more cases begin to arise. Now, there haven't been that many cases involving the Unlawful Enclosure Act, but I think we will see them as the public becomes more and more aware of the fact that they have tools in their old kit bag in federal laws and maybe some state laws. States have powers here too to access public land and to answer questions such as, just because you own 10,000 acres of land privately doesn't mean you can keep me off of the 2,000 acres of public land you're trying to claim for yourself.
Yeah.
That's why you don't see a whole lot of Unlawful Enclosure Act cases recently.
Yeah.
But I bet you'll see them going forward.
Yeah, I think the market sometimes the market gets out in front of itself, and I'm talking about the free enterprise real estate market is selling certain rights, i.e. the ability to exclude the public, which you guys just cited all these cases, and I look at the pile of print-offs you guys have here, there's more where these came from, right? In effect, the realtor is saying, hey, here's what's going to come with your property. So along comes some buyer from, Georgia or Texas or North Carolina. I don't mean to pick on
Ohio. Could be Ohio.
Yeah, wherever.
Could be a bunch of crazy Yankees.
There you go. But there they are accustomed to absolute, this is how it is. And so they come here without doing any investigation. They buy into the idea that, hey, one of the rights I'm acquiring is the ability to exclude others. And they've been able to do that for a long time. No one's really challenged the issue. And now we're starting to see some challenges to this.
That's true.
And I agree with your prediction, Tom. We're going to see more challenges to it because I don't know if this is right, but in my simple head, it's as if we've allowed by this process new property rights to almost be invented, even or quasi property rights where someone believes or invents in their own mind that, hey, one of my rights is this. And now people are saying, no, well, just wait a second here.
Yeah.
I don't know that necessarily is a right that you own.
Well,
I think that's right.
that's right. And what happens here, and I don't mean to monopolize this conversation at all, but the law changes over time as more and more facts come to be. I mean, how many people were recreationalists in 1900?
Zero.
Yeah.
They were too busy trying to make a living.
Yeah.
Make a living, right?
Things have changed since
and
then.
if you came out to Montana to recreate, a bear ate you,
Yeah,
right?
exactly. You were president of the United States. You were Theodore Roosevelt and his friends.
Yeah, that's right. And so the law of property wasn't looked at from the standpoint of what rights, if any, does a recreationalist have in connection with federal or state lands. And as those facts develop and more people come, legislators and lawyers look at the law to say, what about this? What does the law say about recreationalists or hunters on public land?
Right.
And so there's an analysis done that has never been done before. And people begin to look into what is the bundle of rights and sticks you have when you own private property.
Yeah.
And how does that bundle change, or how is it affected by all these recreationalists who are coming who just want to access public land? And now we're looking at it.
Yeah, and I think you're exactly right, Tom, that the pressures change over time. So we talked about the Unlawful Enclosures Act back in 1900 or whenever, totally different world than we are in now. The users are totally different than they were then, by and large.
Great point.
You know, what people want to do is totally different. The idea back then of thinking it would be fun to walk, all over Hellengone to, chase elk or something like that, probably didn't occur to you when you were trying to get all your potatoes in the dirt cellar. It's different now, and what people want to do is different now. And as Tom mentioned, the over time, as it has done since the beginning of laws, things change.
So back to this premise, we've talked about some federal statutes and such. We had this crazy thing happen in Montana, and this is going to touch on two topics. One is about how legislatures behave in response to things as much as the court behaves in responses to things that change. I don't know where this fits in, but some people will say, well, let's just file a eminent domain action and let's just solve it that way. Easier said than done, because there's the practicality of the person or the party filing is going to be a federal agency, and you're never anyone who thinks the Forest Service or the BLM is going to file a really broad eminent domain claim on every one of these corners. Probably is an idealist of they're at the peak of the pyramid of idealists.
Totally.
Yeah.
Totally.
So from a practicality standpoint, that's not here as a solution. Even if it was, wouldn't private landowners have a takings claim and damages in all these instances? So it's nice to say do that, but in practicality, is it? I mean, can we just kind of say, hey, folks, in today's world, that's not going to happen. And okay, so if it's 160 or 1.6 million acres, that means there's, thousands of these places where you'd have to file eminent domain.
Well, I don't know, Randy. In doing the work that Nick and I have done, I've got a little different view about that.
Oh, really?
Would you like to hear it?
Yeah, for sure. Now that you said that, we got to hear it.
Well, the BLM has specific statutory authority to condemn, take my eminent domain. I'm going to take a foot of your ground and I'm going to pay you money for it.
Right.
They have the specific right to do that.
Right.
States have the right to exercise eminent domain and take property by paying money. So as we've been talking, and Nick and I have talked about this, let's just use the BLM.
Yep.
Say the BLM started to say, okay, at every corner where we have public-private land, we're going to condemn 4 feet from the point where they all meet out on private land. We're going to condemn that, take it, and pay a private landowner for taking 8 to 10 feet of his property. So then you'll have an 8 to 10 foot swath where you can go from one public section to another.
Yep.
And a private landowner can't affect you.
Okay.
How much is 8 to 10 feet worth in something like that?
I have no idea.
Yeah, and I don't either, but I'll bet you it's not billions of dollars. And the BLM would have the right to do that, and they're going to be saying we're exercising our mission, we're accomplishing our mission of stopping these corner crossing arguments and buying land so that the public can go across.
Yeah.
And let's say they start to do that, and they take 10 of them.
Yeah.
And if I'm a private landowner sitting back there, I'm thinking, now let me understand this. The BLM is now going to pay me some money and take a little bit of land I have in these corners. And who are they going to let in? Is it going to be just hunters? If it's 8 feet wide, it could let in ORVs,
Right.
horses,
Vehicles.
bobsledders, whatever, who might come through. But the BLM has the right to do that. And the thing is, the BLM could let, and this is a cautionary tale for landowners. If it got to be that way, or if there was a real nice thing on public land that the public couldn't get to because of corner issues, if the BLM begins to take property, or a state does, which a state could,
Yeah.
they control, the BLM or the takings entity, the government, controls the scope of the taking.
Right.
By that I mean who can cross,
Right.
right? And if I'm a private landowner, I might think, do I want to have ORVs crossing at this corner where they're going to strand on my land if it's not fenced? Or would I prefer, if I'm a smart landowner, to grant an easement to the BLM? Because if I, as a private landowner, grant the easement, I control the scope.
So you could say foot only,
Foot only.
or it's only 3 feet wide, or whatever.
No off-road vehicles.
Right.
No horses, no bikes. So I perceive, and you're hearing it here first, friends, I think as the pressure comes from more and more people wanting to access public lands, there's going to be more and more of an incentive on private landowners to say, I'll give you an easement, but here's who can cross my land to get to public land, because that they can control. And if I were a private landowner, I would not want to have a bunch of motorcyclists crossing at a point, and then are they going to wander into my property? They might.
Yeah.
But if I gave an easement only for hunters, or only for people on foot, or no motorized vehicles, I can now control what I think is going to be coming, which is more and more access to public land. And so if I was a private landowner, I might want to take the situation in hand myself and begin to negotiate those easements to keep the pressure off federal and state governments to condemn them.
You realize what you just said, Tom, is going to have every state BLM director hair on fire when this launches. Like, no, now my phone's going to ring off the hook, every one of these public recreationists. And then the others are going to be all these, wealthy landowners who have land locked up saying, you aren't going to do that now, are you?
Well, but yeah, I might, and hopefully they'll both send me a box of cigars, and Nick too, because that is a solution to this problem. And if I owned, how big a ranches do we have here in Montana?
Oh, we have some, 50, 80, 100. The one southwest of town here is 140,000 acres.
Yeah,
he did land trades to consolidate everything within his property.
Yeah, and if you inholdings, public inholdings are a whole other can of fish.
Right.
But some of these same principles apply. Yeah. But if I'm a private landowner and I see how much pressure is developing to let the public gain access to land they own, would I want to control that? Or would I want to let the BLM control that?
Right.
Or let a very, very progressive Secretary of Interior control that.
Yeah.
I'd want to keep it myself, and I'd want to have guys with big feet crossing my corners and not much else.
Yeah.
But they can do that.
Huh. Never thought about it that way.
And the BLM would love that
Yeah.
if they could begin to negotiate easements and not have to take them.
Right. Well, I guess I'd always cross that one off my list. It never dawned on me as a possibility. I don't know that we have we touched much on the civil trespass thing, because what's the benefit for a landowner, like has happened in Wyoming? What's the benefit of them even filing a civil trespass claim against these 4 non-residents? Why would you do it?
Well, that probably goes back to the initial distinction that we talked about between, criminal and civil law. So you could have a scenario where the court decides in a criminal trespass case, hey, this isn't trespass. Mm-hmm. But you could also then have, on the civil side, you can ask for the court to say, well, based on the civil law, this would be a trespass. You passing through the air over the property is enough of an intrusion to be a trespass. And what's interesting on the civil side with trespass here in Montana, at least, is you don't have to. You can have a claim for trespass and not show any actual physical damages to anything. You say, hey, you just violated my airspace, basically. And I think we could probably all agree that, as Tom put it, bruised airspace seems like it's a bit of a stretch. But what might you ask the court to do? Well, maybe you ask the court to say, hey, you can't do this. So the court says to the folks that you sued, hey, you're not allowed to do this corner crossing anymore. Maybe that's what you want. Maybe you say, I'm really going to swing for the fences, and I want the court to punish these people who used an articulating ladder to cross over a corner so they were sure not to touch any of my property. I want them punished for that action. And I want the court to make them pay me punitive damages because of what they did.
So not actual damage to their property, but punitive because what they did is egregious. And
It's a tort.
Has there ever been cases where let's say the true damage was $20, but the punitive damage was $20,000?
And I'll give it to Tom. Tom's raising his hand.
Wisconsin. I mean, as you mentioned, in working on our work here, Nick and I have talked with law professors. We've talked with some eminent professors who are experts, nationally recognized. One of them pointed out a case in Wisconsin where a guy who had a trailer wanted to move it from public land, a roadway, to his property. This is not a public land case. It's private land.
Okay.
He wanted to move it to his property, and there was a 10-foot strip.
10 feet is all he crossed of private.
Right. Well, there was a highway, and then a 10-foot strip that Pete owned, and then his land was on the other side of that 10-foot strip.
Right.
And Pete kept saying, you can't do it. Don't do it. I don't like you. You don't have permission to use my land. A lot of refusals by Pete to say, you can't move your trailer across my land. The guy who owned the trailer finally did it. Just hooked it up, drove it across 10 feet of Pete's land, parked it on his private land.
Yeah.
Pete sues for trespass, civil trespass. It's a tort. It's like hitting somebody.
Right. So it's the landowner against the guy who drug his trailer. So there's no sheriff, there's no DA. Nothing. This is two private parties.
Civil trespass.
Okay.
A civil trespass claim. He goes to trial in Wisconsin. And in a civil trespass case, your remedy is damages, and it doesn't turn necessarily on what you did in tearing up land when you trespassed, as Nick said. So there's a court there, and I don't know if there was a jury or not, but in the end, the court finds here was a civil trespass. We're going to assess damages against the guy who moved the trailer, actual damages of $1.
$1.
$1. And because he did it deliberately, it was a deliberate tort, we're going to assess an award of punitive damages of $100,000.
Whoa.
And so for moving your trailer, when you've repeatedly been told, don't come onto my land, and you do it anyway, that's a civil case and a civil finding and an award of damages. $1 for actual damages and putting your tire tracks on Pete's land, and $100,000 because you deliberately violated his property rights. So that's one case, but that's the scenario that Nick was talking about in the civil trespass case. You get damages, but how much? It's not dependent upon what damage you do to the land you cross.
So maybe this landowner in Wyoming is saying, all right, if the damages are $1, because I really have a hard time in my mind manufacturing how much I damage someone's property when I step across 1 foot on public, swing my foot slightly over their private, and put my other foot on public. The damage in that case seems to be 0. Okay, I'll give them the benefit of the doubt. It's a penny or $1. All right, let me leave my $1 on a fence, tacked to a fence post over there. Mm-hmm. I don't even think it's $1. But what you're saying is if I do this, maybe this landowner, this is from North Carolina, I think, is hoping that there will be such punitive damages to maybe deter people, or maybe would a court say, look, the damage is only $1, but the next person who does this, we're not going to look favorably. And we reserve the right to add punitive damages, or can they even say it that way?
Well,
is he trying to use it as a way to scare people off?
Yeah. I mean, the short answer to that is yes, I think so. That he's asking, as I understand it, the court to say, hey, these guys trespass and I've been damaged by that. As we just talked about, the 1 foot swinging through the air and bruising the airspace seems like it would be difficult to say that you did any actual damage to the land. But what you want the court to say, or if you're the landowner who says, I own this thing out, from these 4 planes, from this corner, these 4 planes go up, and if you cross through my airspace, you've trespassed. You want the court to say, yeah, you can't do it anymore. Maybe we throw some, damages and make you pay this guy because he said that this is, he warned you that it's trespassing. And then you have, created a case that says that this is trespass. And so then the next time that it comes up, the judge is not going to say, I'll keep this case open, and if you do it again, I'll get you again, most likely. But it's a scenario where you say, oh, well, this case was decided here in Wyoming, and this is a trespass. And so the next person that does it, hey, the basis for trying to, punish them, either through a criminal or through a civil suit like we're talking about, is that much stronger because it's happened before.
But one thing to keep in mind, though, about that, Randy, is that every state has its own laws that will apply to when punitive damages are appropriate.
Oh, okay. Yeah, that's good to know.
And sometimes you don't meet them, and they're assessed by the finder of fact, which is either a judge, if you don't have a jury, or a jury.
Okay.
So if the hunters, and I'm getting ahead of myself. And so this $100,000 thing, I don't know what, in that example, Pete had told the guy.
Wisconsin case you're talking about.
Yeah, the Wisconsin case. Who knows how egregious that behavior had been. But it takes, like Wyoming, you can always say, I want a jury to determine this. Mm-hmm. And so it would really turn on the facts if there are going to be any punitive damages, is one thing. And secondly, the reason the Wyoming landowner is probably maybe filed a civil claim is to hedge his bets. If in the criminal case, a jury says these hunters did not commit a crime, that case goes away. And then the landowner still has a civil case. Okay. Let's go ahead with the civil case. They're civil and criminal are two separate things. Yeah. And so he's got another claim. We might call it piling on. I mean, you could say that. I mean, why? You have to ask yourself, why would a guy who owns, I think it's 20,000 acres in Wyoming,
Yeah.
why would someone want to file a civil claim against 4 guys from Missouri trying to hunt for meat?
Yeah.
And you can, I don't know, maybe he'll tell us at some point.
The optics don't look that good, but you know what? That doesn't necessarily matter.
They don't. But if I'm living in Rawlins, Wyoming, and all I want to do is go out and get some meat for my family, or just enjoy the sport of hunting, it's kind of hard to understand why someone who owns so much and is not even a Wyoming resident wants to deprive me of that. It's optics, like you say, and it's a position that will have political ramifications in the sense that people who don't like what's happening here and the benefit being given or trying to be claimed by one landowner, against all these Wyoming hunters or others, why that would be a popular political position. Or if I'm a legislator and I get to be elected to represent my Wyoming constituency, whose side do I want to be on?
Yeah.
We'll see. It'll play out. And I'm not trying to condemn anything. I'm just wondering why.
Yeah.
Why?
So what the term nuisance is often thrown out there. That, oh, this is just a nuisance. Is there some sort of definition to that, or does it have an application here, or is that just, all of us keyboard warriors say, no, this is what Google told us. It's just a nuisance.
Well, there is nuisance is its own thing, so to speak, in the law, and it's related to property, like we've been talking about with trespass. You can maybe think about it as sort of a cousin to trespass, but the general idea behind a nuisance is that it's something that interferes with your comfortable enjoyment and use of your own property.
Okay.
So it's different from a trespass in the sense that it doesn't have to be that I come into your house and walk around and get mud on your carpet, that type of thing. But it could be that next door to you, I actually opened up a fireworks stand, and all my customers are testing out the wares at the stand, and I'm open from 2 a.m. to 5 a.m. and they're there, and that's when we do business. Well, that might be something that interferes with your use and enjoyment of your property. You're trying to sleep.
Happening on a neighboring
even though I'm
property.
doing it on my even though I'm doing it on my property.
Yeah, and you have actually, Randy, blundered into just a beautiful example of limitations of property rights with the fireworks thing.
Yeah.
I own private property. I'm doing something on my property. I'm running a fireworks stand.
Yeah.
And I'm just out in the middle of nowhere, but I'm using my property in a way that impairs or unreasonably interferes with the rights of another property owner. So that's a limitation on your absolute right to use your property any way you damn well please.
That's now that you mentioned that I didn't understand. I stumbled into that, but so it shows that there is not this absolute thing. There used to be a guy over here south of town like 15 years ago. He didn't want people to buy property next to him. He had a little sign that said, "Future home of Happy Oinkers Pig Farm." It was on the corner of Patterson and Fowler on the southwest corner. And I'm like, I knew someone who knew him. I'm like, what's the deal there? Well, he doesn't want any neighbors. So he says if people move in, he's going to put in a pig farm there, and it's going to foul up and stink up the whole area. Would that be a nuisance? Or maybe because it's ag, but because
it's ag. But I think a nuisance is actually based on actions a private landowner takes.
Okay.
And here, to circle back, to give private landowners in the context we're talking about something to think about. In that Camfield case, the first big case in the Unlawful Enclosures Act, they used the word nuisance. The court used the word nuisance as one of the bases of what Congress was trying to stop was the nuisance of private landowners keeping people away from public land. So it's kind of in play in what we're talking about, and it is a limitation on what a private property owner can do with his or her property,
To the detriment of
another property owner, or to the detriment of others. And here, the other property owner would be the federal or the state government that owns the
and
land.
the citizen.
And the citizens.
Huh. I never.
Astounding concept, but a good one. I mean, it really fits in with what we've been talking about.
So, there's so much that I feel like we're just scratching the surface here, because you guys I appreciate that you have sent all these cases and citations to me via email. My brother's a logger. He would have preferred that you printed them all, and he could sell more trees to the paper mill.
We're happy to help your brother.
But I feel like we're not even getting to everything that applies in this situation. I mean, we're just...
Well, it's a big, like Tom said, it's a big topic. It's a complicated topic, and there's a lot of nuance. And to circle back to one of the things we talked about at the beginning, when we're talking about the law and applying the law, we're really a lot of times talking about what are the specific facts that we're applying this law to, and what maybe does the law say when we apply it to those specific facts. And that's been the basis of what we've talked about here a bit is this idea of, well, we know we've got all these laws around, we've got cases, we've got statutes. How does that affect the public's right to use, get access to the public lands? And we don't have any type of answer to say, hey, it's exactly this or exactly that. But what we can say is, hey, it's in flux.
Yeah.
And here's some things that might work. One thing I'll mention to you is we came across while we were working on this and looking at things at a really wide-ranging article in the Wyoming Law Review.
Yeah, you sent it to me. I read that. I'm like, oh my gosh.
Yeah.
This is like a roadmap.
It's kind of like a roadmap, and somebody could put a cite to it. We actually wrote to the Wyoming Law Review and said, can we use a link to this article? And they said, if somebody wants to. But it's written by a law professor named Shelby Green, and it really talks about, here's the title of the article, No Entry to the Public Lands. And then it goes towards a theory of a public trust servitude, which is an easement, for a way over abutting private land, a corner crossing.
Yeah.
It's 14, I'll give you the formal site, 14, Wyoming Law Review, 19. So that's the 14th volume of the Wyoming Law Review, and it begins on page 19. It is an astounding compilation of a lot of these concepts we're talking about.
Yeah.
Talks a lot more about federal statutes, common law, state statutes, and the public trust doctrine, which we haven't even talked about in this podcast. And if you link this up, let's say in your website, your brother's going to make a fortune as people
print it off.
Print it off, yeah.
Well, I am going to put that out on my website. When I put the link to this podcast, I am going to put Professor Green's document out there because there's so much in there that when you guys sent it to me, fortunately, I was back in Minnesota with a whole lot of time on my hands waiting for my mom's cancer treatments. And so I was reading an awful lot of these citations. And I mean, you got to be careful when an accountant tries to interpret what a court case is. But it was, it really was a pivot point for me to start asking you guys the question I've asked you 100 times is, how ironclad, how absolute is this ad coelum doctrine that everybody is basing their current position on when it's to their favor? And
Professor Green also talks about how property law evolves.
Exactly.
And what changes it. And it's an astounding article.
Yeah.
And I guess I'll say two things. There are a lot of legal concepts like the public trust doctrine. Okay, lots is written on that. And you might think, hey, man, I'm just an accountant. I don't know what public trust means. Well, in this article, and in others, you can get the explanation of what it means in 2 paragraphs. And one thing I found out, and so you can understand it and read this and think your own thoughts about it. And another thing is that in the law, in medicine, in accountancy, for most everybody, and I'll bet you most every hunter, if you speak English and talk slowly and don't try to use a whole bunch of technical terms, you can understand.
Right.
And you can explain to somebody what's happening, and the person listening or reading it can understand it.
Yeah.
And so I would hope the people listening to this podcast aren't deterred by, oh God, I'm not going to read a Wyoming Law Review article. Guess what? If you read this, and you'll see the doctrines and the concepts explained, and you'll have a real good grasp of what's going on in this public-private land. What is it? Dynamic.
Yeah.
And it's changing over time.
So, whether it's a Wyoming case, whether it's a whatever case, but since there's cases in Wyoming, a what if, and where I'm going with this is the warning I got back in 2014 that, hey, the legislature can change all this. So maybe we get a finding in a Wyoming case or, whatever state it ends up being. But we'll use this one just because right now it's out there. The finding comes back that, for all these reasons, all the many cases you were citing at the beginning of the podcast, Tom, and all the research you've sent me, Nick, that the court finds that the ad coelum doctrine is not as absolute, Mr. Landowner, as you want to make it believe. These hunters are okay, well, whether it's on the criminal side and or on the civil side. The Wyoming legislature looks at that and says, well, the court said the ad coelum doctrine doesn't apply. We're convening again in 2024. We're going to change that law. We're going to say it does apply. Can they? Is it that simple for a state legislature to say it applies?
I think it would be something that the state legislature could do. How are they going to write the law? What's the law going to say? I don't know. Law doesn't necessarily need to say, hey, the ad coelum doctrine applies. It could just say, hey, if you corner cross to hunt and define what corner crossing is, crossing at the point from public to public, that's still illegal, and you've got a fine or a potential jail time or whatever the legislature decides to set out for the penalty. It could pass that law and change the law that then the court has to apply the new statute.
Could it also change something that applies to the civil side of a claim like that? That says, hey, you swinging your foot over and here's where I'm going. It wasn't long after I embarked on this project that along comes a bill in the Montana legislature to impose minimum civil damages, even if I thought the damage was zero, but I'd give them the benefit that it was $1. The Montana legislature came forth with a bill that I've heard through some who would know that regardless of the outcome of the Wyoming case, we're probably going to see this bill reintroduced in Montana in our next session in 2023. That bill in Montana was to, maybe it was before I started this. I can't remember. But anyhow, it was about the same time. $1,500 minimum statutory damage. Even if the actual damage was a penny, the state legislature said, we're going to just say this is what the damage is.
Well, there are two things about that. 3 things. Number one, they can say that.
They can. Yes.
They can say it. They can pass a statute that says civil trespass. You step off the sidewalk onto my yard and pull your foot back. That's a civil trespass. If you're found guilty of that, no, not really guilty, but you're found to have civilly trespassed, the minimum fine is X, $1,500, $5,000. That's the minimum. Can be more. Okay, they can pass it. The next question is that constitutional? To punish somebody so out of proportion to their activity, allow that to happen in a civil case. Now, we're not talking criminal.
Right.
So there are constitutional limitations on punishing civil behavior.
Okay.
And I think, Nick may disagree, but I think when you begin to impose those kinds of fines, it's not cruel and unusual punishment, in the criminal sector, but it doesn't bear a rational relationship to the behavior you're dealing with. And there are some constitutional limitations on how much you can charge somebody. And there's a third political point. How would you like to be the representative from a district up in the Missouri breaks with all those hunters and others, and you want to tell the 3,000 hunters in your district that they're going to get fined if they do that because you're trying to benefit one 40,000 acre ranch landowner. There's a political price you pay for that kind of activity too. There just is. And you have to think long and hard about, do you want to begin to mess with a lot of Montana hunters to benefit somebody who owns 40,000 acres and lives out of state? I mean, I think with the right kind of publicity, that could be a populist issue, and it might be detrimental to a legislator.
Tom, are you implying or goading me to use my platforms to?
No, Randy, I never did. No, but I got to say, as Nick and I have looked at this, we have scratched our head and wondered why are people, like with that legislation you just talked about in Montana, or with what's going on in Wyoming, why are so many state officials, legislators, prosecutors, others, working so hard to benefit extraordinarily big landowners at the expense of your populace?
Yeah.
It doesn't make sense.
Welcome to the new plutocracy of the Gilded Age.
We are.
We got rid of that 140 years ago, and here we are. It's not the Standard Oil and the Rockefellers and the J.P. Morgans. It's other people, and I know that sounds kind of tongue in cheek, but history does have a pattern of repeating itself.
Well, and when you could acquire 40,000 acres or 20,000 acres, you have been very successful, right? You've acquired a massive amount of wealth, and God bless you. Right. That's what capitalism is about. And then the question becomes, what are the limitations on your use of that, and how much can you use that power
to exclude the right of others is what's in my head.
Yeah, that's right. But guys who just men and women who just want to go out and catch a fish, right, on a stream running through public land. Why would you do that? Yeah. And the one thing I'll tell you, Randy, is from having lived a life, and I'm now 175 years old, and I've read a lot of history, this has been an issue from before the time of Christ, right? Yeah. Wealthy people have more power than people who don't have it. Yeah. But it's different when you're back in the land of Nebuchadnezzar and you're here in the United States of America. It's different. Yeah. And we'll see how it plays out.
A lot of people will interject, stream access or water law, public ownership of navigable streams into this. I haven't really heard where any of that, in none of the cases that you've sent me or that we've talked to, or when we've had these Zoom calls with some of these law professors, no one's really brought in stream or water law as applicable to this.
We haven't talked about it. You're right, Randy, but whether it's applicable or not, I'd want to spend a little bit of time thinking about before I give you an answer to that. It's a whole different, ball of wax. In Montana, particularly, the history with stream access is really fascinating. Historically and from the development of the law, that perspective. What impact that might have on an issue like public access to public lands, I don't know. But it's what's interesting about it in Montana is just how robust the right is for the public to have that stream access.
Yeah. And the reason it enters my mind in Montana is Jim Getz, who argued the case. If you ever had the chance to talk to him, he would tell you that, and I'm going to paraphrase the way he said it to me, is, everyone thought we were crazy, because it was a long-held tradition that, well, I'm going to run you off the stream here. I don't want you parking, floating your boat, anchoring out in front of me or whatever it might be. Well, it took some rather strong-willed fishermen, Montana residents, some hard thought and legal analysis, and now we have what most would deem to be the best stream access law in the United States. And all these posturing of, well, this will be a takings, and this will be a that, and this will be a this. As Jim, I heard him say one time when he was speaking, and I often say this, I might have said it earlier, is, over time, people tend to create property rights they don't really own. And unless there's pushback, that becomes accepted. And again, I don't want to put those words in his mouth, but it was kind of the way that Montana pivoted in a direction on the stream access law that I wasn't here at that time. I think it was 1987 or whatever when that case.
Phenomenal law.
Yeah. I see, even if in the letter of the law there isn't the exact parallels here, in terms of the history and the trends of certain parties making claim to rights that they, in their own mind, invented more so than were presented to them or came with their deed. As long as nobody challenged that right, it was just like, well, I guess that's how it is. I don't have the money to go fight this shit. I don't want to go to jail. I don't want a punitive assessment against me. And so I'm thinking about that similar parallel in when you 6 months ago, before you guys started this, I would have been 100% in the camp that, hey, this ad quorum doctrine is civil trespass, and I'm never going to do anything that's civil trespass. I just, I respect property rights.
Yeah.
Mm-hmm. All the work that you guys have done, that others have chimed in with, and I'm very grateful to those who have lent their time and have, you guys keep copying me on these emails with these others. I'm grateful to their help too. All of this has me now doubting, is this ad coelum absolutism? Is this just something that's been invented and no one's ever challenged it? And, I don't know where the outcome will be, but I'm a hell of a lot less worried about this ad coelum doctrine being some moral violation I would have of my ethos. Because I'm wondering, Tom, what were the language you read in that first case or two about you only own whatever you need and the rest belongs to the world?
What you're using.
Yeah.
What you're using is
what you are using is what airspace you own. And the rest belongs to the world. And there's all these kind of cases that have similar findings to that. And as one of the professors we've talked to said, I'm surprised no one in the recreation and hunting space hasn't brought this forward before now.
I could give you a law school lecture on what you've said, but one of the reasons is cases arise from specific facts. Mm-hmm. You don't just dream up a fact scenario and get an answer. You get guys arrested down in Wyoming. Mm-hmm. Here's specific facts, and here are the issues come up.
Right.
That's one thing. Secondly, this article we cited about Professor Green,
this
talks about the public trust doctrine in a really good way. and how it might apply, like the stream access law or laws involving streams apply in Montana. I think that's coming for public lands and the clash between public and private ownership will be there. And third, I mean, Jim Getz has been brilliant in what he's done and what he's accomplished, he and his law firm, for hunters and people who want to access public land or public resources. Another thing I'll say is that, not to make a plug for lawyers, because a lot of people don't like lawyers, but how do you think all these cases came about? Who was litigating on behalf of the landowner, or the fisherman, the hunter? Private landowners. Who's advocating for them? It's lawyers.
Right.
And I would encourage people to think that there are boatloads of lawyers who are public land advocates.
Yeah.
And I would encourage hunters, fishermen, organizations that support them to think that there's a way for them to advocate for what they want. It's not foreclosed to them. Just because somebody says, I got a bunch of land in Utah, Wyoming, Montana, and I am telling you you can't come in. That ain't the law. And if you want to challenge that, get a lawyer who spends time and effort, and you might get a different answer, or you might be able to push. And some lawyers, I hate to say this, some lawyers do this stuff for free because they really believe in accessing public lands. You will get someone who could at least challenge that and maybe change the law or get an articulation of the law that is different from what the private landowner thought.
Right. And for me, I'm looking for a clarification of this, because before, you would have, if you went and talked to a lot of people, they would have said, oh, this is absolutely clear. I mean, this is how it is in this country. In the last 6 months, I even more so in the last 2 or 3 months, as you guys have been just loading this on me as your research has been coming together. I think that window, looking through it, that this ad coelum is some absolute principle, is I fully understand why people want to make the claim. Okay, if I own this property, maybe I'd want to make that as this is the absolute way it is in this country. But I can't look at the mountain of papers you guys have here and not begin to doubt what I've been told most of my life. That this isn't absolute.
Well, I think that's a really good point, and particularly this idea of it being some absolute idea that everything above the land I own, like Tom pointed out, it's been a long time in the law here in the United States that there isn't some absolute rule that you own everything up to the heavens. It's not a clear-cut idea. It's not a clear-cut idea that you start owning at 1 foot, 2 foot, 5 feet, 10 feet, wherever. All these are I can't tell you what that line is where it comes into play, for the reason that Tom pointed out, which is that the law develops from the facts when they're presented here to the courts or to the legislature, whoever's going to interpret the law or make the law, to say what it needs to be, and it responds to the needs that the people have over time as those change. So I think you're right. This idea that, hey, there's only one rule that you need to know about private property and public property coming together at a corner, and that's that there's a absolute right to exclude anyone from crossing through the airspace. I don't think that's an accurate statement of the law. Can I tell you what it actually is, or hey, here's the exact answer? No, I can't, because we're not there yet in terms of what the law says. But as Tom pointed out and you pointed out, as user patterns change, as different groups become more engaged or active or interested in trying to assert their access rights or their right to enjoy the public land as a citizen of the state of Montana or the citizen of the United States, say, hey, these are mine too. it's not just a matter of you've got this invisible wall that means I can't do anything, then I think we start to see things change.
Yeah.
Here's an odd coelum story for you, Randy, that I heard. It might be apocryphal. It might be made up. But I heard that one time there was an accountant who got a helicopter on private land, on public land, and the helicopter picked him up and took him at a few hundred feet over private land and put him down in the middle of public land that was surrounded by private land. He shot a bull elk there because he had a hunting license to do it. And then he strapped the bull elk to the helicopter, lifted him straight up over public land, and then flew over the private land with the bull dangling down, right, back to public land, and was able to get an elk. Now, you tell me that was a trespass?
Well, if it's a trespass, I trespassed 5 times.
Oh, that was you? I'm shocked to hear that.
And it cost me about $600 or $700 of airplane or of helicopter time every time I did it. So I paid for the benefit and privilege of trespassing.
And these guys from Missouri down in Wyoming spent gas money coming out to Wyoming. But that story about the helicopter, that's passing through air over private land. Is there anybody alive who's going to say that was a trespass? And then you land on public land, shoot an elk legally, bring him out? The real question is, why should you, as a Montana citizen, have to pay hundreds of dollars to access a huge inholding of public land to hunt elk? When the elk, who owns the elk? The state of Montana.
Right. Held in trust for the citizens of Montana.
Right. And we're getting into public trust concepts here and also airspace here. So what's the difference between a footstep, an inch and a half above a corner, and a guy coming in on a helicopter to access public land?
Yeah. I mean, on the helicopter, I don't know that we were ever more than 400 feet off, 500 feet off the ground.
So that, as Nick was saying, that ad coelum doctrine, it's gone, long gone. And it was a nice concept at the beginning by an English jurist who had a lot of money and made the pronouncement, and it just doesn't play, as the U.S. Supreme Court has said. It doesn't play anymore.
Yeah, in a number of the cases that you've sent over, there's language in there about how some of this is just impractical. To apply that concept in today's world is impractical, impossible, or they use some terms to make it pretty clear that, it might work good on paper, but in the way the world works, it doesn't work it doesn't work at all.
I think that's exactly right. The as much as Tom alluded to, folks liking to take pot shots at lawyers, the law does try to accept some practicalities from time to time. And it, like you say, it's just not practical to imagine that, hey, I own everything going up for my land. I mean, good luck flying anywhere. Yeah. Let alone getting in your, renting a helicopter and getting that little short, bump over to the public land. Yeah. It's just these concepts give way in the face of the facts of life as we experience them and as they change over time.
Yeah. Yeah, I'm trying to remember who it was back a long time ago. Says power concedes nothing without pressure.
I've heard that. I can't remember.
Trying to remember. I have it written down somewhere.
That's totally true.
And now I forget who said it. Hal Herring who was the first person I saw publish it in the context of how we as public recreationists are only going to get what we apply pressure to get, because the current existing power will concede nothing out of benevolence.
Right. Right.
And so I'll tell you guys this, we got a lot more work ahead of us, because I've told you what some of my future thoughts and ideas are with this. So I feel like we're just getting started. But the investment of our time and money has been worth every bit of it, and then some. And I think for me, and I think I can put myself in the shoes of most of my listeners, the last thing we'd ever want to do is violate someone's property rights.
Yeah.
That's just who we are as people. and someone wants to use the hyperbole of, well, that's the same as if you came and pitched your tent in the middle of my living room. No, it's not. It is not the same.
Right.
The courts. Tom has that pile of dead trees there stacked in front of him. I noticed, Tom, you do. Is this an age thing? You have all kinds of paper printouts, and Nick's got all kinds of stuff on his
Absolutely.
computer. Okay.
I like holding the paper and highlighting it.
But this pile of paper shows that hyperbolous example someone wants to use is not how the courts look at this. The court would look at it completely differently if I went and pitched my tent in somebody's front yard.
Right.
Yeah, well, those facts would be completely different.
Exactly. So to try and make these analogies when the facts are like bicycle tires and donuts or bicycle tires and ice cubes is just, it doesn't fly. And I think a lot of times that's done, and I've fallen for it at times because my hypersensitivity to being labeled someone, oh, you don't respect property rights. Bullshit. I live by that.
Yeah. No,
What I don't live by are people creating property rights where the law doesn't necessarily say it exists, to the detriment of other property owners.
you have hit the nail on the head, Mr. Newberg. That's exactly what it is.
Really?
That's exactly what it is. Yeah. I mean, to say it's like Chicken Little. If you let somebody cross a corner, they're going to pitch a tent in your living room. That's an argument based on this idea that property rights are set in stone, or that they've been totally determined and there's nothing more to determine.
Yeah.
It's totally different. What we're trying to do is just have an accommodation really between two property owners, public and private, based on what the concept of property is.
Yeah.
Yeah, it's fluid. And those kinds of arguments, the argument, those set in stone arguments are really, I don't want to say anti-intellectual, but the law is out there.
Yeah.
And you can read about it, like in this law review article we cited. And guess what? They're really nuanced.
Yeah.
They're really subtle. And oftentimes, as we've talked about a lot in this podcast or this conversation, the facts haven't been presented yet for a court or somebody else to consider.
Yeah.
And so you make the stuff up.
Yeah. Well, I really appreciate all your time. I look forward to our continual work on this. I don't know where it'll lead. It'll be interesting to see where the Wyoming case ends up.
Yeah.
I personally, and this is just my read of it, now reading the civil case that's brought forth, it's like, all right, it appears as though this landowner is going all in, doubling down, or I mean, I'd say all in. And again, this is just someone who has become way more submerged in this than I ever thought or wanted to be. What's the possibility that he's out there so far on the plank and he's pushing this issue so far that he ends up hurting this case, that this absolutism of the ad coelum doctrine? I mean, he's really pushing the boundaries, it appears to me. Maybe I'm wrong.
Well, what do you think a Wyoming jury is going to decide? It's not going to be the judge who decides this.
Yeah.
I think there's a jury in this case. How do you think the jury will decide whether these guys violated the law or not? And how do you think the landowner's actions would affect you if you're a drywaller in Rawlins, Wyoming, who likes to get an elk every year?
Yeah.
What would you think about that?
Yeah, I'd love to be in the jury selection meeting.
Well, we have to think about who are the public lands users. That's all of us.
Yeah.
That's everybody. It's not. It doesn't. You don't have to have a big fancy truck. You don't have to have the latest gear. You don't have to have your own big parcel of land that you own. Mm-hmm. You just get out and walk.
Yeah.
And that's the beauty of it. And the spectrum of folks who do that is huge.
Yeah.
You know, it's something that brings everybody. I think one of the great things about living here in Montana is that it's a great unifier and leveler. Once you're out in the mountains, it doesn't matter how fancy your coat is or how big your bank account is. It matters if you can handle yourself, and those opportunities and that experience that we get to have is shared by a lot of people who care about it deeply. And I think, you know, folks react to the idea that, hey, actually this doesn't belong to you, it belongs to me. Yeah. No, it belongs to all of us.
Right.
And I think that's powerful.
Yeah, I know certainly from a standpoint of public sentiment, I wouldn't want to be running on the platform of, you know, I call it bulls for billionaires. In other words, bull elk for the billionaires. That's I started using that phrase a few months ago when Montana tried to dramatically change our structure of licensing for all the frustrated billionaires from out of state who you have to get a helicopter to fly over their ranch. They've expressed their frustration that they can't get their bull elk tag, and they're going to have to stand in line with all the peasants. Those non-residents. I mean, why? You know, I'm too good to stand in line with them. Me and my agents are going to exercise our influence. So I call it bulls for billionaires, but it's the same here. It's, you know, we as people who've been successful, and like Tom said, great credit to them. You know, they figured they've worked hard, they've had some good luck, and things went their way, and you know, they've been successful. But that doesn't mean we are back in, you know, the day of chopping people's arms off or, you know, quote unquote, getting the king's rabbit. Or, you know,
right.
I mean, we're beyond that. We have established law to some degree that says this isn't, you know, you might think you own this. Your realtor may have told you own this. Your title insurance policy, certainly, I've examined a lot of title insurance policies. I've never seen one that specifically said that you own all the airspace. Maybe there are policies out there, and if so, go file a claim against your title insurance policy carrier.
That's right.
I haven't seen that policy either.
And so, point of that is, you know, I have come around to the comfort and being comfortable that pushing this, challenging this, thinking about it, and forcing some clarity to it is in no way a violation of my personal ethos of respecting property rights. If anything, it supports my ethos on that because it needs to be clarified. Mm-hmm. We need to understand this. And we can't do it at disregard to the public's right any more than we can do it to the disregard of the private right.
There's no other way to be. That's not anarchy. That's not taking the law into your own hands. It's just saying, let's clarify the law, or let's pass statutes or whatever we might do, so we understand and then obey what the law is.
Yeah.
That's really what it is. It's admirable. It's admirable. And I got a million things I could say, but, you know, I just think Nick and I, with this job we've done, you should take us on a helicopter ride someday, Randy.
In your invoice, are you like, you guys haven't charged me for any expenses, just time. So accountants, we take the actual cost and mark it up 10%.
No, we record our time and charge for the time we bill.
Oh, okay.
No markup.
Okay, so I wouldn't get charged for the helicopter time?
Oh God, no.
No.
That would we'd be off the clock.
All right.
And then we'll have a big elk feed somewhere.
Well, guys, thanks so much. This is not going to be. I would seriously doubt this is going to be the last time you appear on this podcast. Unless all of a sudden the world gets clear and law becomes settled.
Yeah, well,
but
then we'd be out of a job.
We'd be out of a job. We really appreciate the opportunity to talk with you about this too. It's a basic fundamental citizenship kind of law and issues. that Nick and I both really enjoy and really care about, and we appreciate your passion for this too. And we're lawyers. We want to find a way to these answers under law, and we appreciate the fact that you do too.
Yeah, well, I appreciate it, gentlemen. Thanks for all your work so far. Hope I haven't imposed on you, scared you off, or acted too crazy where you said, we need to analyze if we want to continue to have this guy as a client.
Not yet.
Not yet? All right,
yet.
Give me enough time, Tom.
Okay.
Folks, thanks for being here. Lots to think about. You'll be hearing a lot more on this from me and on my platforms, and big thanks to Tom and Nick and all the other attorneys who've given us the benefit of their time and expertise. And we'll see where this goes. Thanks, folks.
When the sun